been some really interesting developments in one of Australia's most beloved musical groups, the Wiggles. Their former CEO, Luke O'Neill, is suing the Wiggles, and also, as a second respondent, Anthony Field, the Blue Wiggle. And they're commencing action under the Fair Work Act for a breach of the general protections provisions, in addition to a claim under the Australian consumer law for misleading and deceptive conduct.
That's right, as well as a contractual breach claim as well.
Absolutely.
Yeah.
There's so much to be discussed in the pleadings, but today I think we focus on the general protection provisions themselves. So what he's alleging is that after a string of various complaints that he made to individuals within the company about certain staffing and operational decisions, he was subject to a form of adverse action in that they reduced his responsibilities. They excluded him from key operational decisions and meetings, and then eventually terminated his employment without any prior notice or performance manage. So that's why he's elected to press forward with the form of the claim that he has, the general protections provision of the Fair Work Act. Now, everyone knows, or is familiar with the concept of an unfair dismissal claim under the Fair Work Act. But I can still see there's some confusion about what this specific claim is, a claim under the general protections provisions. What is the difference between a general protections claim and an unfair dismissal claim?
Great. Well, the unfair dismissal claims is basically an instance where someone's dismissal has been unjust, unfair, or unreasonable. And that isn't actually available to all people. So in order to be someone protected from unfair dismissal, you need to be under a particular income threshold, so under what is called the high income threshold, or alternatively be covered by an award, as well as have served a minimum period of employment. And that will vary between 6 and 12 months according to the size of the employer.
So there's more restrictions upon who can actually leverage an unfair dismissal claim.
That's right. There's more eligibility considerations as to whether or not an unfair dismissal application is available to an individual. In unfair dismissal applications, there is also a cap on what can be ordered to be paid by the employer by way of compensation. And that's either a specific sum or 6 months equivalent to that individual's pay at the time. Conversely, in the general protections or adverse action jurisdiction, there's no such cap. And so Luke O'Neill won't be constrained by any cap that applies to unfair dismissal in the event he can actually demonstrate that there has been adverse action taken against him throughout the course of his employment and up to and including its termination.
Interesting. So say that both claims are available, you hit all the eligibility requirements for the unfair dismissal claim, but you're considering which jurisdiction or which claim you want to proceed with. Is it a strategic option for some potential plaintiffs to choose the general protections provisions because they want to increase maybe the quantum of damages that they might eventually be awarded?
Absolutely, and I think it is as well. So the other element is, and as we've seen with joining Anthony Field and in fact some additional respondents to the proceedings, you can actually also seek penalties and penalties against individuals for having engaged in contraventions knowingly about which the plaintiff or the applicant complains. And so it actually enables the court to award penalties, so civil penalties, and seek greater compensation, including against those additional individuals. So we don't often see that in the unfair dismissal jurisdiction, but it is something that's available in the general protections division.
Right, and it's a different standard, it's a different requirement as well for most people to consider. Even though you can potentially recover a greater quantum of damages and penalties and all the rest, it's not as straightforward as proving that your dismissal was harsh, unjust or unreasonable. So what are the technical difficulties that a plaintiff will have to overcome if they do choose the general protections claim?
Yeah, so what they're going to have to do is demonstrate that the adverse action, and again that can take form in various ways, so be it sidelining, exclusion, being denied certain rewards or incentives or entitlements, demotions, as well as termination. You have to demonstrate that those adverse actions were taken as a consequence of the exercise of workplace rights. And those workplace rights can take the form of making a complaint or making an inquiry about your rights and entitlements, or how, for instance, certain decisions or actions might impact those entitlements. So that's here where Luke O'Neill has said, well, hold on, some of my remuneration is closely related to, you know, the spending, expenditure and hiring decisions within the Wiggles. And where certain decisions were taken without deferring to him or in consultation or his approval, he's saying, well, that's going to impact my earning capacity and my entitlement to certain bonuses because of the financial performance of the business. I want more information about this, or I want to, you know, be involved in these steps moving forward, or questioning why certain decisions have been made. And he's now alleging that he was sidelined and there was a diminution in his duties and responsibilities as a consequence of that. So he needs to allege that, but in this jurisdiction there's an unusual kind of difference, and it's almost like a reverse onus, whereby the employer then needs to demonstrate that the actions complained about weren't actually taken as a consequence of the exercise of the workplace rights.
So it's that because of question, the causal link between the workplace rights, whatever they be, in this case a string of complaints, and then the following action. So employers will typically say things like, well, yes, that happened, the complaint maybe was made or was not made, but the action wasn't taken because of that discrete complaint.
That's right. And oftentimes a really good way of employers delineating between the actions, the exercise of the workplace right, and then the subsequent actions taken is, for instance, creating some distance around the employee and the decision maker about that change that's complained about. So whether or not the decision to demote Luke O'Neill in this instance was as a consequence of him making those inquiries or complaints, or was that a step to be taken irrespective?
So it will be a really interesting case to follow. I'm sure we're going to be following it really closely, and I'm sure it's going to attract massive media attention just given the status of the Wiggles. So we'll keep our eyes peeled.
And the importance of the Wiggles to many households, mine
Absolutely.
inclusive.